can a defendant delete incriminating text messages and photos from a cell phone, and after he's convicted, cite to those deleted messages as a grounds to undo the conviction? To find out, you have to read People versus Hartle, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less, if I can do that. This is the episode on the case of People versus Hartle. The citation to this case is 2023, New York Slip Opinion 02029, published by the Court of Appeals on April 20th, 2023. The issue in this case is the application and meaning of CPL, Criminal Procedural Law 440, which permits a court to vacate a conviction on the basis of newly discovered evidence. To understand what's going on with this case and appreciate what's going on in terms of the law, you have to understand CPL 440.10. CPL 440.10 says that a conviction can be vacated if new evidence has been discovered since the entry of judgment based upon a verdict of guilty at trial, which could not have been produced by the defendant at the time of trial, even with due diligence on his part, and which is of such character as to create a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant, provided that a motion based upon this ground must be made with due diligence after the discovery of such alleged new evidence. And the other thing you have to understand is that when a court makes a decision on the basis of a CPL 440 motion, those decisions are reviewable as an abuse of discretion basis. So the appellate court will be reviewing the trial court's decision or the motion court's decision for abuse of discretion. What are the facts here? The facts are that the 50-year-old defendant had a sexual relationship with his friend's 15-year-old daughter, minor child. During that relationship, he and the child exchanged explicit text messages and photographs, but both he and the child deleted those photos and text messages from their cell phones. The defendant was ultimately subsequently arrested and charged. They seized his cell phone, and they held his cell phone the entire time of the trial. He never asked for it. He never sought it to be forensically examined or anything like that. At trial, his defense was it didn't happen. The defense was there never was a sexual relationship. His lawyer cross-examined the victim about the lack of any text messages with friends discussing the relationship or any disclosures. The defendant was ultimately convicted and sentenced to 54 years in jail with 10 years of post-release supervision. Here's the thing. Years afterwards, the defendant got a forensic analysis done of his cell phone, which was able to recover the text messages, the photographs that were deleted by the defendant. And he made a motion to say, under CPL 440.10, my conviction should be vacated because these show a lack of forcible compulsion, and I was convicted under some theories of forcible compulsion. The trial court, the motion court, reviewed that and denied it without a hearing, said, I find the allegations are insufficient to justify a hearing, and I also find this is not newly discovered evidence because the defendant created the evidence, and he deleted the evidence. How could they be newly discovered if he deletes it? The appellate division affirmed it. It goes to the Court of Appeals. And here we have a majority and a dissent, and they're very interesting. The majority says that the court was right. They say there was no abuse of discretion. That's the standard, remember, to apply here. They say the evidence was not newly discovered. The majority says this was evidence the defendant knew about, he was involved in the creation of, he intentionally destroyed to conceal. He's not allowed to now claim that since technology did not exist to recover the incriminating evidence back then, that the evidence is now newly discovered. He knew about it, even though he's the one that deleted it. And the second reason why they say there was no abuse of discretion is they say that the defendant failed to meet the due diligence requirement. They say, the majority says, the defendant never tried to get the cell phone before the trial. And the assertions that he gives are conclusory, inadequate, and self-serving. So they say the defendant must show an effort to obtain the evidence before trial, and here they didn't do that. But there's a dissent here, a dissent by Judge Rivera, joined by Judge Wilson, who's now the new chief judge of the Court of Appeals. But Judge Rivera says that the trial court, the motion court was wrong, and the majority decision is wrong. They're saying not that the defendant should have his conviction vacated, but he's entitled to a hearing. Judge Rivera points to the statute and says, the statute is written so there's a presumption that the defendant gets a hearing. It says 440 motions must be given a hearing unless the elements are not met. And here, the elements are met. There's newly discovered evidence by the terms of the statute. Newly discovered does not mean the defendant didn't know about it. What Judge Rivera and the dissent says is that it's irrelevant whether the defendant knew about the evidence, whether he deleted the evidence. The only question here is, was the evidence available at the time of trial? And on that point, it's sort of undisputed that it was not available. Why? Well, it was deleted, but that's not relevant to whether it was available or not. And on the issue about whether there was due diligence, the dissent says all the elements here are satisfied for 44010. There's affidavits from a forensic criminologist. There are certain affidavits from other people that the presumption should prevail here. The presumption that the defendant gets a hearing, that is satisfied. So the dissent says that this is wrong, that the defendant should have gotten a hearing, but the majority says the defendant cannot call it it's not newly discovered if the defendant created it and then deleted it. And that's the case of People versus Hartle. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.